SJC-13672 in the matter of an impounded case.
Hi, okay, Attorney Clay, whenever you're ready.
Thank you. Good afternoon, Your Honors, and may it please the Court. Attorney Kyla Clay on behalf of the mother. We're here today because there's a gap in the law concerning the appropriate standard of review that juvenile courts should apply when a parent objects on sincere religious grounds to routine, non-urgent medical care of their child in temporary state custody. Under the First Amendment, parents have a constitutional right to determine and direct their child's religious upbringing. Under Santosky versus Kramer, this constitutional right is not taken away when the state obtains temporary custody of their child. When DCF obtains temporary custody of a child, it has the statutory authority under Chapter 119, Section 21, to make decisions about the child's housing, education, and medical care. This includes decisions on vaccination. Ordinarily, if a parent disagrees with DCF's decisions for any reason, the trial court reviews the decision for an abuse of discretion. But because a parent's constitutional right to make religious decisions is not revoked or passed to the state, an objection based on a sincere religious belief cannot be subjected to the same standard as any other objection to DCF's custodial authority. And that is the gap that we are here to address today. During this period of limbo, when DCF has temporary custody of the child under a mere preponderance of the evidence standard, how should courts assess a parent's sincere religious objection to DCF's decisions of ordinary medical care? Right now, we don't have guidance on this issue. So we are asking that this court hold that a parent's religious objection to DCF's decisions of ordinary medical care must be subjected to a balancing test, considering the interests of the parents, the child, and the state.
Yeah, go further. So what, is it strict scrutiny in a conventional sense, including a least restrictive alternative analysis? What is it? Because I get it that we're in a gap, but the U.S. Supreme Court's very, very protective of these rights, and I'm not sure they're sort of an open-ended balancing test is going to make them happy, right?
Right. So as discussed in the amicus brief, the strict scrutiny standard would essentially require that the government have a compelling interest and that it's narrowly tailored to meet that interest.
Why are you not arguing that? Is that you're not arguing the strict scrutiny standard?
So I believe that the strict scrutiny standard in a lot of ways is a balancing test, and in cases of extraordinary medical care, the Supreme Court has held, or the Supreme Judicial Court has held, that that in Ray McCauley we can apply a balancing test, which includes a consideration of the parents' interests as well as the state and the child's. So I think ultimately this court could go either way. It could adopt the strict scrutiny standard, or it could instead adopt the balancing test set forth in Ray McCauley.
Your position is regardless of the balancing or strict scrutiny, the outcome is the same?
Yes, that ultimately the parents' religious objections need to be granted greater deference than any other objection to DCF's custodial authority.
Assume it was a balancing test. What would our standard of review be for the judges? Because it looked to me like the judge did a balancing. So what would our standard of review be for the outcome for the decision of a judge who applies a balancing test?
I believe the standard of review would be an abuse of discretion standard. But to your other point about the trial court conducting a balancing test, I would respectfully disagree. Instead, I think the court essentially decided that DCF can move forward because vaccines are generally good and universally recommended for all children.
Right, and he balanced that against the interest of the parents in a sincerely held religious belief.
Well, the court failed to make a failed to consider the child's specific interests as well as the state's interests, and that was the ultimate failure in that level. Specifically, the court failed to conduct an inquiry into the child's specific circumstances as to why this child needs to be vaccinated. Instead, it relied on affidavits that all children in general need to be vaccinated. And then the court failed to address the state's interest here, which is significantly diminished because of the fact that the legislature permits parents to make religious objections to their child's mandatory vaccination.
Can I understand? I'd like to understand what the state, from this record, the exemptions that are allowed. So if this were not a child in temporary custody, state law would allow the parent exceptions from the vaccinations, is that right?
Yes, state law provides all parents. It doesn't distinguish what type of parent.
Just
but-
again, so if this were not a child in temporary custody, exemptions are allowed for these kids, right?
Yes.
And the three other children of this family were given exemptions under what statutory authority? Because they were also in temporary custody, right?
Correct. They were in temporary custody when DCF chose.
How did they get their exemptions?
So essentially, the exemptions will kick into place when a child is being enrolled in daycare or primary school. So the exemption would be simply telling the school or filling out a form that they would have a religious exemption.
I'm trying to understand, because, again, back to the U.S. Supreme Court, because they're ultimately going to evaluate free exercise clause. The Supreme Court doesn't like sort of haphazard exemptions in religious areas. So I'm trying to understand what the exemptions are here. Why were those three children, the other children, not vaccinated? What was the legal justification for not vaccinating them according to our record?
There is no reason provided. The record does show that DCF told those three boys' doctors that they would not have the children be vaccinated because of the parents' sincere religious beliefs against vaccination. And yet, for some reason, they've decided to vaccinate this child, and the subject child. They don't describe why exactly they permitted those three boys to be unvaccinated, but that was the decision that DCF ultimately made.
So are you arguing that this is a Fulton type of case? The amicus argues it's a Fulton type of case. Are you arguing it's a Fulton case, or are you, because that's a different standard than the balancing test that you talked about earlier.
Right. So the Fulton case talks about how the government can't have these individual discretionary authority to grant or not grant religious exemptions. And I think that if there was a balancing test, that would essentially put that decision up to the judge as opposed to the department. However, a strict scrutiny standard would also be appropriate here. I think it's up to this court to decide whether a balancing test.
But again, back to Justice Wentland's question, you're not saying we should either do Fulton or strict scrutiny. You're talking about this more open-ended balancing test.
Right, and I derive this balancing test from In re McCauley, which was a case held by this court where.
McCauley is a case involving a potential death of a child from leukemia, right?
Right, and the parents objected on religious grounds.
And they weren't in temporary custody.
In that situation, the department did, I believe, have legal temporary custody of the child, not physical custody.
Because of the medical issue, right?
Yes, correct. And ultimately, I think that this balancing test would be appropriate because the juvenile courts are well equipped to employ it. They are familiar with it because of In re McCauley. I do think a strict scrutiny approach would also be appropriate, though. But ultimately, what matters is that the parents' religious objections have to be granted a greater degree of due process than what the department is advocating for, which is a mere abuse of discretion standard. The right to make religious decisions on behalf of one's child, this is a right that is deeply respected by the United States Constitution and by our courts. And this balancing test that we propose would allow.
The Supreme Court directly addressed this temporary custody religion issue they haven't weighed in exactly on this, have they?
No, they have not. And in fact, this is an issue that hasn't really been addressed by many courts in general. There are about 3 cases that have addressed it, in 3 out-of-state cases. One of them is an Arizona Court of Appeals case, which held in our favor and did believe that a balancing test would be appropriate. And the other was a case in Arkansas, a Supreme Court case, where they also held in the parents' favor, primarily because of the religious exemption granted by the statute, and the fact that that statute doesn't distinguish between a parent who has full legal custody or temporary custody revoked.
I'm going to mispronounce this, Delitus, or what, the Mass case that says we provide a higher standard of protection requiring a concrete and specific analysis. Can we decide in your favor on sort of very narrow grounds that when the DCF is saying 3 other kids in the same family who are in a family foster care don't need to be vaccinated, and this kid does, that's a problem for them, and we don't have to resolve all of these major issues? I don't know what the standard is, and I'm not sure what we do, but it looks odd that we've got 3 kids in the same family in the same situation, not vaccinated, and then a kid who is vaccinated.
Right, and I think that this court could certainly resolve it on the fact that that decision was arbitrary and capricious, and I think that and that would be appropriate. However, there is this gap in the law that
It's arbitrary and capricious, but it's not specific and concrete to this particular child's circumstances, is it?
It's not. It's certainly not. And they will claim that the child is in foster care and will be removed at any point, and so that's why she's at a greater risk of harm. But the department fails to inform the court that this child is also in kinship foster care, just like the 3 brothers. And indeed, they also will state that she's a younger age, but when they first took custody of those 3 boys, the youngest boy was 11 months old, and this child right now is 13 months
Can I
old.
ask another? Sorry, go ahead.
Sorry, was there anything in the record to suggest that the medical providers for the 3 boys had provided a letter attesting to the medical necessity of vaccinating the 3 boys, such as they had for the girl?
No. However, this letter is just a general recommendation that all
I
children
don't know.
should be
It says,
vaccinated.
I don't know. I'm looking at the first paragraph, and I don't know that that's a fair characterization of the letter.
Well, the rationale that they provide is because it's generally recommended by the CDC.
Well, that seems to me something for the trial court to weigh, but the first paragraph does say that this affidavit is filed to attest to the medical necessity of administration of routine immunizations for the infant. I won't say her name.
Right. And
Okay.
I will note that in the Arkansas and the Arizona cases that I've mentioned earlier, that was the exact same situation. We had a child, an infant child, and we had affidavits from doctors attesting to the medical necessity. And yet those courts still held that because of the religious exemption that the legislature provides, as a matter of public policy, parents' religious rights outweigh the state's interest in vaccinating children. However, if this child had specific medical needs or conditions that rendered her more susceptible to risk, that could be very well a different situation, particularly under a balancing test, but also under a strict scrutiny standard because it needs to be narrowly tailored to that child. And ultimately, that's what the trial court failed to do. So,
One last question.
yes.
Court, are there any, this is a year old, are we going to be discovering court records that this case is, that there's been some determination on parental custody? Do we have a permanent decision out there on this family, or are we in the right status, right where we, is this where we are in this case?
Yes, this is where we are right now. The position has not changed. And so,
So he's still in temporary custody, there's no dispensing with the consent to adoption decision or anything like that? Right?
exactly.
Okay.
And the vaccinations haven't occurred either?
Unfortunately, they have been occurring. And the court approved vaccinations for the entirety of while she's in DCF care.
Okay.
So after the temporary custody hearing, but before termination trial, parents must retain this constitutional and fundamental right to direct their child's religious upbringing. It's not passed to the state. And so if this right is to have any meaning whatsoever, it cannot be subjected to the same standard as ordinary custodial decisions under Section 21. It must be granted appropriate consideration and weight beyond a mere abuse of discretion review. Therefore,
Okay.
Oh,
Thank you.
thank you.
We're going to move to Attorney Openshaw.
Good morning, Your Honors, and may it please the Court. My name is Laura Openshaw, and I represent the appellant father. The father joins the mother in asking this court to vacate the order of the juvenile court authorizing the vaccination of the child over the parent's
Do
religious
you agree that
convictions.
we should be applying a balancing test or strict scrutiny?
I share the counsel for the mother's view of this, which is that both standards accomplish what we are seeking here, which is giving deference and respect to the parent's sincerely held religious beliefs. And
That's odd to me, because when you have a balancing test and you're balancing the parent's interest, the child's interest, and the state's interest, where the parents have lost custody temporarily, that interest necessarily is also lowered because they no longer have full custodial rights to the parent. So it seems to me odd that your position is that if we apply strict scrutiny, which requires a compelling state interest, and that this is the least restrictive alternative to accomplish that interest, that would be the same when we balance parents who've been found to have been neglectful of the child against the state's other interests, which are compelling.
I would say two things. One is that in this case, there's only been a finding by a preponderance of the evidence at the temporary custody hearing.
A finding of what?
Of either immediate risk, in this case, immediate risk of neglect, versus a finding of unfitness requires a finding by clear and convincing evidence with a number of procedural safeguards. That's a very different standard.
Right, but you'll grant me the proposition that these parents, because of whatever interim finding, have a diminished interest necessarily under the balancing test because they have been found to have been neglectful.
I think Santosky versus Kramer tells us that the interest is not diminished, that these are when a fundamental liberty interest is concerned, that's a right that remains with the parents and does not, and that only is, parents are presumed to be fit and to make decisions in the best
How about the
interest.
third prong? Because I think you may be fighting hard on something, but the third prong is clearly different. The least restrictive alternative is really tough. And if you've got 3 kids getting non-vaccinated and 1 kid getting vaccinated, and you got all kinds of exceptions, it's the least restrictive alternative thing that should be very important to you, isn't it? I mean, and it's, like Justice Wellman, I'm confused by why you're not pushing that, because
Right.
that's your strongest argument.
This is like a Lukumi Babalu sort of case where we have what the state is asserting to be a compelling state interest, and the means that the state is using to accomplish that interest, both are, there's no regulation or authority that compels DCF to vaccinate everyone. And there's also no means to guide the DCF's decision-making.
Well, but what it is they grant exceptions. And if this child hadn't had a temporary custody finding, that kid wouldn't be vaccinated. So that's where the least restrictive alternative seems to be very different from, because there's a compelling interest in vaccination. It's going to be tough. It's really, are they doing it in the least restrictive way possible? This kid doesn't go to daycare, doesn't go to school. I think you may lose under your balancing, but you may win under the least restrictive. So just help us out here. Why you don't want that?
Right. Well, I think under the Fulton case, the question isn't whether it's a compelling interest writ large, it's whether it's compelling as to this particular child, and that's where the consideration of her specific circumstances needs to be considered.
May I, Chief, I'm sorry, may I ask a question even though the time has expired? I take it that you and the mother both agree that the calculus is different if there is a determination or stipulation to unfitness.
That's correct.
Okay. So why is that the case, first of all?
Because it's axiomatic that the parents are presumed, fit parents are presumed to act in the best interest of their children. And it's only after a stipulation or adjudication of unfitness that we can no longer make that assumption.
Okay, so, I mean, I don't want to speak out of school, but maybe I will. The parents did stipulate to their unfitness with respect to the 3 boys, correct?
That's
They have done that.
That's right.
So does that get taken into the calculus at all here? Should it?
As to this child, I don't think it does, because they're still presumed fit as to her.
Okay, and so what is the distinction, the pertinent distinction for this analysis between, for purposes of determining a correct legal framework to analyze the question here, which is, should they be vaccinated over their objection? What is the factor that makes a difference between a finding of unfitness and a finding of the findings necessary to confer temporary custody to DCF, which is risk of imminent harm, neglect, risk of abuse, that kind of thing?
It's primarily the burden of proof, the difference between a fair preponderance of the evidence and clear and convincing.
All right, so if, in your view, if the standard for obtaining temporary custody were clear and convincing evidence, then we wouldn't be here?
Well, I think that would offend due process at the temporary custody hearing stage. But I think the question is, if there has been a determination made by clear and convincing evidence that the standard for unfitness involves a slightly different inquiry. But if there has been either a stipulation agreement or a finding by clear and convincing evidence of parental unfitness, then we're in a different place.
Okay, thank you. Attorney Brathwaite.
Good morning, Your Honors. May it please the Court. I'm Kristen Braithwaite for the Department of Children and Families. And Your Honors, I'm here today asking you to uphold the trial court's conclusion that it was in the best interest of the subject child to allow the department to proceed with vaccinations, and further to ask you to find the best interest test is the proper standard to apply when a parent raises a religious objection to the department's exercise of its statutory authority to consent to the routine medical care of children in its custody.
So how does this best interest test fit in, if at all, into this 3-prong balancing test that your opposing counsel suggests, or the strict scrutiny test that you throw in at the end of your brief?
Well, just to clarify, I did not intend to throw in the position that we believe strict scrutiny applies, but rather to acknowledge the U.S. Attorney General versus Desolate's case, which I think is slightly different. But the real answer to your question is that the balancing test, the beauty of the best interest of the child test, and the reason why it's sort of the capstone test in child welfare, is that it allows a judge to take into account everything, all the factors. So any amount of factors that are relevant to the determination of whether, let me say that differently, there is an opportunity for parents' religious objections to be fleshed out. There is an opportunity for the child's best interests, health-wise.
But it doesn't give this constitutional right any special status, or does it? Because we don't, it's easy, best interests, when we don't have free exercise of religion under the First Amendment of the Constitution. But when we do, we tend to have the Constitution be our focal point, and you have it as the tail on your dog. Help us out here. How do we just push this over to the margins?
Well, as an initial matter, I think, and this responds to a number of questions that were asked of appellants, while parents have a fundamental right to make decisions concerning the care, custody, and control of their children, that right is put on hold when the department meets its burden of proving by a fair preponderance of the evidence that a child is at imminent risk of abuse or neglect in their parents' care, and that removal of the child is necessary to protect him or her from serious abuse or neglect.
What does it mean to be put on hold? Is it irrelevant?
It means that because the department has shown, because the child it's less about the department, but because the child would be at risk in the care of the parents, that is why the legislature then entrusts the department to make these determinations. So while appellants argue that no unfitness decree has issued and therefore they should be treated as fit, that is not actually the statutory framework that exists. And I just want to be clear that I would direct the court.
But don't, help us out, though, because
Okay.
the state doesn't get to make religious decisions. So that, and the parents here could very well be reinstated at, at any point in time. They haven't lost their parental rights. So I'm just trying to get a sense of how we're not going to run into problems here if we just do this the way you're talking about, which is classic best interest of the child, as if this were, what time they go to school or who gets, I don't know. It just seems like it's much more complicated than that.
Well, and this court has the opportunity to direct what factors should be considered in this best interest test. But to answer your question of how we do that, the reason is that, due process requires notice and an opportunity to be heard.
But again,
so in order
you
for
confront the First Amendment, because that's the hard part of this thing. And does it apply? Do we apply strict scrutiny or not?
we do not apply strict scrutiny.
And we don't apply strict scrutiny because this child is in temporary custody. If this child were not in temporary custody, I take it the state couldn't, the First Amendment would apply standard, right? It would be,
Well, even in our cases of religious exemptions for vaccination, we have always the stopgap that if there is a public health outbreak, we have extensive case law that does not speak to children who've been removed from their parents' custody that supports the fact that the First Amendment is not violated by compulsory vaccination.
In extraordinary circumstances, but what you're talking about is routine medical care that's garden variety, recommended by the Academy of Pediatric, blah, blah, blah. So help me, apply what the extreme case law to this situation.
Well, this is not extreme medical care, and so I think it's important to acknowledge that vaccinations are routine medical care, and certainly and for what it's worth, the standard for
doesn't that cut against you? It seems like we've overridden parents' decisions if the child's about to die. But here, you're asking to override decisions in a non-threatening, except for in a general sense, way.
Well, I'm not asking that we automatically override. I'm asking that we leave the best interest test to the judge, because you had made a comment, for example, Justice Kafker, about what happens if the child is about to be returned home. The beauty of the best interest test, which is discussed in many cases, is it's fluid and it allows the judge to take in any evidence that goes in favor of the child's best interest and against the child's best interest.
Doesn't that run right into Fulton and the U.S. Supreme Court saying, when we're dealing with religious rights, they have a special status, and if the state is kind of fooling around, sometimes doing it one way, sometimes doing it another, that's a real problem under the First Amendment. And the fact that you've got 3 kids not vaccinated and 1 kid vaccinated runs right into what is driving DCF?
So I think there's 2 questions in there, and I want to answer both of them. First, to touch on the question of why one child has been vaccinated and the others haven't, I think that evidence is that child-specific analyses were being done. It is incredibly relevant to the urgency of vaccinations that this child was an infant. And if you go onto the CDC's website, they'll talk about the whole point of vaccinations is to provide antibodies that the individual has.
One of the other kids younger than this child isn't?
No.
Okay, what are the age of this child?
This child was put into the department's temporary custody at discharge from hospital following birth, so days old.
There was also an 8-month-old child who wasn't vaccinated, right?
But did not come into the department's custody until much later. And so
How
the
much
relevance,
later?
I believe it was 7 months, but I'm happy to
So it
provide.
was a 15-month-old?
What's that?
It was a 15-month-old child that came into DCF's custody?
Yes, so they were young, but they were not newborns. And it is relevant because newborns have had no opportunity to be exposed to antibodies. And that is the most urgent concern. They were also together, those three siblings. This child is not, and she's going to be exposed to exponentially more individuals. So I think there was some child.
Why is that? Isn't it the opposite? These other kids go to school, they play with other children. This child is an infant and staying in a controlled environment.
So this child will be meeting with her siblings who are unvaccinated and who are going to school and being exposed to a number of people. So because she's in a different home and meeting with her siblings, her exposure is greater. And I would also.
Isn't it greater than for the other kids too? I don't understand why that's a one-way ratchet. If they're meeting with each other, why is she more?
It's
I'm
relevant.
just a real question. Why is she more exposed than they are?
Well, the
Everybody's not
relevance
vaccinated.
here is that she's an infant, and so she's not being protected the way. So the children that were in the parents' care for longer, I don't know what was happening at
So
that
is
time and whether
GCF's
they're being
position,
exposed.
now that the child is no longer an infant, that we don't need to vaccinate anymore?
No, it's the department's position that the judge is best entrusted to make that determination, and that the best interest of the child test allows the trial court to do that, and that the judge in this case was guided by the factors that we've seen in Dessalines.
May I ask a question? Sorry. Do you at least concede that the parent's religious interest needs to be incorporated into the best interest of the child analysis if that were the test that we were to settle on?
I do believe it is absolutely proper for the judge doing the best interest of the child analysis to include the parent's religious interests. But I want to be very clear that I don't agree with appellants that the parent's religious interest should be given special weight. And if anything, I would argue that goes directly against the face of the Commonwealth's jurisprudence, which says that the child's interests have to supersede the parent's
What
interests.
case says that? That would be, what case says, that seems dramatic. I'd love case law on that.
Yes. So I would point the court to Magazu versus Department of Children and Families, while religious belief,
That one cuts against you because that's effectively the strict scrutiny test. That one says if there's a sincerely held religious belief that's substantially burdened, the Commonwealth needs to come up with a compelling state reason why this particular child needs to be vaccinated, and that exceptions to that would jeopardize that goal, that important goal of the state.
well, and it's not the one I should have cited, but I also think it stands for the
Give us
proposition.
one you should have cited.
Okay, I'll tell you the one. My apologies. I would point the court to petition of Department of Public Welfare to dispense with consent to adoption. That's 383 Mass 573. I would also point the court.
What does it say?
That while the right to parent one's child is indeed fundamental, it is not free from intrusion by the state. It is not absolute. And I would also point the court to.
That deals with religion in any, does that even deal with religion at all?
Well, I think all of these deal with whether or not the parent's rights should supersede the child's rights in reaching a determination of best interest. And they talk about fundamental
I think everyone
rights.
understands, we're going to have the compelling state interest analysis for the state. We're going to have, but I just, for you to, it would really be helpful to give us some authority.
Then I would point the court to Prince versus Massachusetts, which I think does make clear that
Prince is the old U.S. Supreme Court case,
it
right?
is, yes.
And one that's been beaten around a fair amount by the U.S. Supreme Court, right?
But one that stands. It currently stands, and it does stand for the proposition.
In that case, was there an exception made by the state for the child labor laws?
For the child.
The labor laws that were at issue there. It was a child who was working because she was with her parent, and there was a child labor law that said you can't have children working.
I
Was
don't
there
recall
an exception?
whether there was an exception made in
No, but
that
see,
case.
that to me, that makes a big difference, because here the state has allowed exceptions for religious reasons.
I would also point the court to Blixt v. Blixt, which is, again, it uses strict scrutiny, although using strict scrutiny, it finds that the best interest test can withstand that. But I think it also stands for the proposition that infringement on the rights of parents is permissible when necessary
Is
to
that a
prevent.
domestic violence case? I can't remember. Is Blick's the religion case?
What's the what one?
Blick's the religion case? No.
I believe there was, I know it was a family law case. I apologize.
It was
I
the
don't-
grandma who wanted visitation rights.
Yes, grandparent visitation. That is what it was. It was about whether or not harm would befall the child by allowing a grandparent to visit over the parent's objection to
Right,
such
so we
visitation.
supported the parents' rights to limit the grandparent, right?
But there was extensive language about the fact that infringement on the rights of parents is permissible to prevent harm to the child. And again, I know I'm out of time. I really want to end on the proposition and point the court to adoption of Zayden, which is that these fundamental rights are put on hold when the child enters the temporary custody of the Department of Children and Families. And I think that's highly relevant to the determination that a juvenile court judge would be making in the context of a
And I
parent
hate to
protection.
belabor it, but put on hold, again, back to Justice Wendland's formula, put on hold is not the language in the cases. What do the cases say? They don't, they do what? They limit it somehow, right?
Yes, so.
But again, it's different with religion because the state can't take over religion either.
It says parents have a fundamental right to make decisions concerning the care, custody, and control of their children. But General Law, Chapter 119, Section 24, protects that basic right by prohibiting the department from removing from a parent's care, even temporarily, unless it can show that removal is necessary to protect the child from serious abuse or neglect. Here, a court of law ordered the child out of parents' care for her safety. The conditions of removal were litigated. This is, at this point, a battle between custodians, and this is one where I do not believe that the parents' fundamental rights are being infringed.
Okay, thank you very much.
Thank you, Your Honors.
Okay, and finally, Attorney Kaiser.
Good morning, Your Honors. My name is Jean Kaiser, and I represent the appellee child who is now 13 months old. And on her behalf, I would ask this court to uphold the trial court decision so that she can continue receiving vaccinations and other medical treatment that protect her from potentially life-threatening but highly preventable diseases. And I first want to address the court's question about strict scrutiny. Strict scrutiny does not apply in this case.
Your brief doesn't even apply to the Constitution, as far as I can remember.
Excuse me?
Your brief doesn't even address the Constitution, right? It's all a statutory
No,
interpretation.
that's incorrect.
Okay, so
I do have a section, a large section.
what do you say about, if strict scrutiny doesn't apply, how do we incorporate the Constitution into your analysis?
Okay, well, I want to back up for a minute and explain to the court why strict scrutiny does not apply. Strict scrutiny applies when an individual is exercising their own religious right. The United States Supreme Court has never held that when a parent is imposing their religious belief on a child who is too young to have their own religious beliefs, and this child certainly is too young.
I would love to read a case where the Supreme Court says that. Do you cite something on that proposition?
Absolutely, Your Honor.
The U.S. Supreme Court has said that a parent
In Prince
is not
versus-
speaking for their child on a free exercise. That's an interesting point. I'd love to read the case. What is it?
Prince versus Massachusetts says, while parents are free to make martyrs of themselves, they are not free to make martyrs of their children who are too young to have religious beliefs. Similarly, in Wisconsin versus Yoder, which involved the case in which people of the Amish belief did not want to send their children to school, the court said in such a case, the court should impose a balancing test that takes into account the rights of the child, the rights of the government, and the rights of the parents. Now, in that case, the court found that the balance favored the parents. But it was not a strict scrutiny test, it was a balancing test, and I think that's why appellants have...
In those two cases, do they expressly say strict scrutiny doesn't apply, or do they articulate balancing without rejecting strict scrutiny?
They don't explicitly say strict scrutiny does not apply, but it,
Prince is before the strict scrutiny formulation by the Supreme Court.
That's
It
correct.
predates it. So really, it's Wisconsin versus Yoder is your best case for this point.
I think, too, that this court itself applied the test promulgated by the appellants in Macaulay, matter of Macaulay, and in custody of a minor, in which.
So can I ask you about those cases? Because those were extreme medical situations. The child will die if we don't do this.
That's correct.
How do we apply that context to routine medical care, such as routine vaccinations?
Well, to answer that question, I want to speak to the issue of what exactly are the parents' rights in this case. So the parents have, any parent starts with a fundamental right to raise their child as they see fit, including the right to direct their religious upbringing. However, when the court intervenes, the consequence here of the trial court finding that these parents put their child at immediate risk of severe abuse or neglect is that their fundamental rights have been interfered with, and that includes their religious rights. What they're left with, and there's a footnote in another case called custody of a minor, that says that they have certain residual rights to determine the child's religious affiliation. But so already what we're dealing with here, differently than in Macaulay and custody of minor, are parents whose rights are very attenuated.
Right, so you're already applying the Macaulay test. My question is, why do we apply Macaulay in the context of routine vaccinations, whereas Macaulay was a test, at least as applied in minor and in Macaulay, for extreme child will die if we don't intervene situations?
Well, in Macaulay, there is no language that says this analysis is limited to child will die. And I do point in my brief to several out-of-state cases in which a similar type balancing test was applied, even when the child wouldn't die. But aside from that, Your Honor, I would say I don't think we even need to get to the balancing test, because I think this case could be decided under the plain language of the statute. And in my brief, I address.
Well, I mean, it seems to me that's a hard one, because the statute just says routine, or it says medical care decisions can be made by DCF. This case presents the question of when the parents have a sincerely held religious belief against vaccination, does 21 allow DCF to go ahead nonetheless? And even DCF didn't just do it. They actually went and applied to the court for permission because they recognized that there was a balance that needed to be required.
That's correct. But if you, so let's say we apply the balancing test. So the balance, I think, works out to favor the child getting vaccinations, because the parents' rights are, by the nature of the fact that the child is in temporary custody, quite circumscribed. The child's right to be protected against serious disease is at issue, and as is the government's right to make sure children in their care are protected. And one thing I want to add here, Your Honors, is that in this case.
Can I push you again? So I see that in some ways, but then I say to myself, if the government's right is not exercised with the three other kids, and it's not obvious to us why this child is differently situated than those three others, doesn't it suggest the government is kind of picking and choosing when it really cares about this? And that's problematic, because these parents, care in the sense that they're here, they're challenging this, and the state kind of picks and chooses when it wants to do this.
Your Honor, I can't speak to why DCF didn't have the other children vaccinated, but I can speak to my client's interest in being vaccinated. And I also want to note that the parents' objection, their religious objection to vaccination, is because they do not believe in putting foreign substances into the child's body. So the logical extension, if this court were to find that their religious objections trump the child's interest in remaining healthy would also be that if the child has a fever, that the foster parents would not be able to give her Tylenol to treat that fever. And in fact, the father testified that in a similar circumstance, because of his religious beliefs, he would give the child a bath and some tea.
You don't really want us to go into the sincerely held religious belief issue, do you?
I think that the court, there's no,
We don't have a factual record. From what I understand, also, the parents, there's a continuance that wasn't allowed, so the parents aren't present. Do you really want to go back to that?
no, I'm not going back to that, Your Honor. I think the trial court did exactly what it was supposed to do, which is that it assumed the sincerity. The court is not allowed to get behind whether or not the religious belief makes sense or is inconsistent. It is a question of sincerity, and the court assumed the sincerity. But what I am saying is the impact on the child of medical decisions being made according to these parents' religious beliefs when she is in temporary custody because they were found to have put her at risk. And so it means that, can she get antibiotics if she has an ear infection? Maybe not, because the parents might object to that. And it creates a situation where DCF has to keep going back to the parents, whose rights are, according to this court, their residual rights are limited to determining her religious affiliation. No one is trying to change her religious affiliation, but it would be very onerous and it would entangle DCF.
The case that you're talking about that just limits the rights to religious affiliation, was that case just about that issue?
No, absolutely not. That is just a footnote in another case which says the parents retain residual rights to visit the child, consent to adoption, and determine the child's religious affiliation.
And none of that in the footnote was the issue du jour for that case. It was all
has
dicta.
Absolutely nothing to do. It's just a sort of a, but I would note that the statute that's referenced with regard to religious affiliation is actually the Foster Parents' Bill of Rights. And all that it says is that the foster parent should respect the child's cultural background. It doesn't say that they should have to make sure that every religious practice that the parents would prescribe is followed.
What is the distinction, if there is one, between the balancing test that you are advocating and the balancing test that the mother is advocating, other than an application?
I think it's just the application.
Sure, okay, that's helpful to me. And what do you see as the distinction between the balancing test that you're advocating and the best interest of the child test that DCF is advocating?
Well, I think that in the child's interest in the balancing test is her best interest, right?
That's a factor.
Yes, whatever her best interests are. Here, clearly, her best interests are to be vaccinated. Then you also have to look at the government's interest. So the government has an interest in caring for this child who's in their care and protection, as well as all of the children in the Commonwealth. It has an interest in maintaining herd immunity among all of the children in the Commonwealth so as to protect all children. And then balanced against that is the parent's very attenuated right, because is there an interference here with the fundamental parental right? Yes, there is. But this court in Care and Protection and Robert said that that is a feature of the temporary custody statute for, the pause that the attorney for DCF was talking about. Those fundamental rights are, in essence, on hold while the child's in temporary custody.
Okay, I'm sorry. Does anyone have any other questions?